Tonight we have Zach Peterson from Richardson Law Firm to assist the board in this agenda item. The representatives of Richardson's Law Firm will provide a general overview of how we got here. From there, the appellants will be provided 15 minutes to present their case. Representatives from NextEra will also be provided 15 minutes to provide information. The board then reserves the right to question the appellants, NextEra, or the county zoning officer. I'm going to ask for a motion to approve the appellant's request to have the zoning officer implement a stop order. Motion and second.
I so move.
Looking for a second.
Again, in order to properly have this before the board, lawfully we do have to have a motion and a second before we can have any discussion start on this.
Yeah, I'll second it.
We have a motion and a second. We will request the staff to explain the motion.
I'll wait for you.
Just by way of background on this, this matter commenced on September 30th, 2019 with a letter from Attorney Jared Gass to the zoning officer on behalf of Alan Robish and Christy Mogan. The letter alleged violations of CUP 0817-2018 relating to Crown Ridge Wind failing to secure all required permits and requested a stop work order. On October 16th of 2019, the zoning officer responded to the complaint and declined to issue a stop work order. On October 28th of 2019, a notice of appeal was filed by Attorney Jared Gass on behalf of Mr. Robish and Ms. Mogan. Notice of this hearing was published on November 27, 2019. Interested parties were notified, and the zoning officer's record relating to this matter was transmitted to the Board of Adjustment in advance of this hearing. With that, I would call the appellant forward to present the appeal.
Alan and I are here tonight to ask the board to do its duty and enforce the conditions of the Crown Ridge conditional use permit. We are asking that you, the board, immediately order a cease and desist to stop all construction activities. And we are asking you to consider fines for beginning the construction before meeting all the conditions of the Grant County Cup. We are suggesting a fine of $1,000 per day for the commencement of excavation. On October 16th, we submitted a photo evidence to Krista, the planning and zoning officer. Excavation had commenced on or before September 19, 2019. On September 30th, our attorney Jared Gass did send Krista a letter, and he had stated that Crown Ridge Wind and Crown Ridge 2 has only some of the required South Dakota BUC permits. This is a clear and deliberate violation of the Grant County Cup. It is very simple. The Joint Cup applicants chose to submit one application for the Grant County Cup, and the Grant County Board of Adjustment findings state in number 5, findings of fact, shall not become effective until all required permits are granted by the state and federal government, including the remaining applicants and licenses referenced in the application. This finding of fact is for all required, not some, not half. It is for all the required for the joint applicants. The Planning and Zoning Officer responded on October 16th. I'm going to paraphrase a little bit here. I have determined that the documents required as a condition of the Board of Adjustments have in fact presented by the applicant. The building permits have been issued only for those areas in which the South Dakota PUC has issued all the applicable permits. In accordance to my duties as a zoning officer, I issue building permits consistent with section 401031. That section is not even part of our Grant County ordinance. And to be clear, we're not talking about the building permits here. They're not the issue. The issue is that the joint applicants, Crown Ridge 1 and Crown Ridge 2, did not have all the required permits as required in the conditions of the Grant County Cup. The planning and zoning officer is not following the Grant County Cup findings of fact requiring all, not some, or in those areas. The conditions don't say that. The single Grant County Cup cannot be severed. Your findings of fact require all permits to be granted to the joint applicants. For some reason, the joint Cup applicants chose to apply to the Grant County for one Grant County Cup for two entities. That is fine. That is the joint Cup applicant's choice to do so. But by doing so, both entities must abide by the findings of fact. In the combined Cup application, in which the board relied on to approve the Cup, the joint applicants acknowledged on the very first page the combined Cup application, Crown Ridge Wind, Crown Ridge 2, respectfully request your review and consideration for the enclosed application for A1 singular conditional use permit. On page 2 of that application, Crown Ridge Wind and Crown Ridge 2, together, they wrote together Crown Ridge. They made themselves one entity when they did that, as in joint and combined. On page 4, the conditional use permit application, the joint Cup applicants state Crown Ridge will comply with all applicable federal, state, and local approvals, licenses, permits, variances for the proposed wind project prior to the date of construction. The joint Cup applicants are not complying with the local approval. Construction has commenced without all the required permits from the South Dakota PUC. Crown Ridge Wind 2 does not have a permit that they are currently in pursuit of. For some reason, Crown Ridge Wind, Crown Ridge 2, which applied jointly in the Grant County, chose to separate the project for the South Dakota PUC permits. The joint Cup applicants could have applied for both permits at the South Dakota PUC at the same time. They did not. Half the joint Cup applicants, only Crown Ridge Wind, applied for a South Dakota permit. On July 26th, the South Dakota PUC entered its final decision and order granting a permit to construct the facility to half the joint Cup applicants, Crown Ridge Wind. However, joint Cup applicant Crown Ridge Wind 2 was not named in the PUC order. Crown Ridge Wind 2 does not have any of the required South Dakota PUC permits. South Dakota PUC permit, condition number 2, applicant shall construct, operate, and maintain the project in a manner consistent with all applicable permits issued by the federal, state, or local agency with jurisdiction over the project. So the PUC is reinforcing the applicant shall comply with the local conditional use permit. The PUC application, page 88, a combined application for the Cup to Grant County dated September 17th. The joint Cup applicants acknowledged at the PUC it was a combined Cup application, and that would require all the permits, not some, but all the permits to be granted from state and federal. The joint Cup applicants do not have a Crown Ridge Wind 2 South Dakota PUC permit. On July 9th, 2019, Crown Ridge Wind 2 applied for a South Dakota WES PUC permit, but that decision is months away. It's not even possible for the joint Cup applicants to meet all the conditions of the Grant County conditional use permit until at least March of 2020. The Joint Cup applicants may tell you they have a South Dakota PUC permit for Crown Ridge Wind, and so they may start that part of the project. That's not a true statement. Looking at the Grant County findings of fact number 5, it clearly states, shall not become effective until all required permits are granted by the state and federal government. In the findings of fact, there is no language allowing the Joint Cup applicant an exception to start construction activities without all the required permits. The Grant County Cup does not state some, half, or part. The findings of facts do not state for those areas. It states all. Grant County Cup does not allow any exceptions, and the Crown Ridge Wind 2 does not have a South Dakota PUC permit. The Joint Cup applicants may say they do not have to build all or any of the turbines. That is a true statement, but it does not answer the fact that they do not have a South Dakota PUC permit for Crown Ridge Wind 2, which is required as a condition of the Grant County Cup. It is the duty of this board to enforce the conditions of the Cup. We are asking that the board order immediately the Joint Cup applicants cease all construction activities and they may not be restarted until the Joint Cup applicants have met the conditions of the Grant County Cup issued December 17, 2018 to the Joint Cup applicants. In summary, Crown Ridge Wind 1 and 2 applied at Grant County for one conditional use permit. The Joint Cup applicants chose to apply for separate permits at the PUC. Grant County findings of fact, which there are two separate entities. There's Grant County, and we have our orders and we have our conditions, and then there's the PUC. We are looking right now at Grant County. That's your authority. It says that in our Cup, they must have all permits must be granted by the state and federal. Not some, not part, not half, not in those areas. They must have all the permits for the Joint Cup applicants. The Grant County facts and findings does not have any language in the Joint Cup applicants, in the Joint Cup to commence construction activity before the Joint Cup applicants have been granted all the required permits. Half the Joint Cup applicants, Crown Ridge Wind 2 has not been granted a South Dakota PUC permit. The Grant Cup applicants have not met findings of fact number 5, as the Joint Cup applicants have not been granted all the required permits from the state PUC. We ask that the board immediately issue an order to the Joint Cup applicant to cease all construction activity forthwith until the Joint Cup applicant has been granted all the required permits. We ask that you enforce the conditions of the permit you approved. Stand by for questions and rebuttal.
Okay, we'll have the representatives from NextEra. And we'll have 15 minutes. Thank you.
Miles Schumacher from Lynn Jackson Schultz in LeBron and Sioux Falls. I'm South Dakota Local Counsel for Crown Ridge Wind LLC and Crown Ridge Wind 2 LLC. Appellants here rely entirely on a distortion and misplaced emphasis in the language of finding of fact number 5 to support their argument. It's only by distorting that language that they have any language at all. They're asking you to completely abandon common sense in favor of a distorted interpretation of the language in finding of fact number 5. You have to remember, and by its very terms, the conditional use permit is fully transferable. There's nothing in the permit, the ordinances, or the finding of the facts that says that all of the turbines covered by the conditional use permit have to be constructed by one or the other entity. So even if they were not separate co-applicants, they're not one entity. By filing jointly for the conditional use permit, they remain two entities. But even if it were one, under the terms of the conditional use permit, they can freely transfer the right to build the 2 turbines that are going to be part of Crown Ridge 2 to the second entity. The language of finding of fact number 1 does not say all conceivable permits. It says all required permits. It is not a required permit unless you have to have that permit in place for the construction activity that's covered under the CUP. To build the Crown Ridge 1 turbines, you need the PUC permit for Crown Ridge 1-2. The Crown Ridge Wind 2 permit that is pending before the PUC has no bearing on the activity that is currently under construction. There is no activity on any turbine site that is not fully permitted by the Public Utilities Commission at this point in time. And to argue that the meaning of this common language that's part of the standard finding of fact that says you have to have all your permits before you build, and to construe that simply because we have co-applicants that went in together to condense this into one conditional use permit process on the part of the county, to say that that means you have to obtain a permit that has no bearing, no purpose whatsoever for the construction activity that's taking place now is a complete misconstruction of the language on there. There's no restriction in the CUP that says it cannot be split into multiple projects. The language isn't there, the restriction isn't there. That's not the law with regard to conditional use permits. The conditional use permit does not say all or nothing, that you have to build all the turbines or you can't build any. So for example, it doesn't follow that if the permit from the Public Utilities Commission for some reason is not granted by Crown Ridge 2 and we can't build those 2 turbines, that has no bearing on Crown Ridge 1 that's being constructed now pursuant to a permit issued by the PUC. It just doesn't, the argument doesn't make any sense. There's no common sense behind it. It serves no purpose to require the second project to be permitted before you construct the first. That's not what the language in the finding of fact states. It's important to note that the language of your ordinances with regard to the stop order states specifically that the zoning officer may order the work stopped. It doesn't say shall, it doesn't say will, it doesn't say must. It says may. It is within the sound discretion of the zoning officer to make the determination whether or not a stop order is appropriate under the circumstances. After investigation here, your county zoning officer determined in the proper exercise of her discretion that such an order was not appropriate. Further, the purpose of these provisions in the ordinance is not to be punitive. It's not to punish somebody, it's to bring somebody in compliance. So we know that, and it's been admitted by the appellants, that the permit has been applied for, that it's in process. The steps are already in place to obtain the PUC permit for the 2 remaining turbines for which work has not yet been commenced. The purpose of Chapter 8 in the ordinance is enforcement to see that the terms of the conditional use permit are carried out. They are. They'll all be fully permitted, but for the work that is being done right now, there is no requirement, no necessity, no purpose whatsoever served by requiring a PUC permit for turbines that aren't under construction for the Crown Ridge 2 part of the project. It serves absolutely no purpose, and it defies logic to require that at this point in the process, and it is an attempt to institute punitive action that's not authorized under the ordinances. We would urge that the finding of your county zoning director be upheld.
The board is open for discussion. You can speak to Mr. Peterson, representative from the next area, and amongst each other.
I just have one question. You said something about you could, up to Miles, you said something to the fact that you could go ahead and transfer the two from that you, Crown Ridge 2 into Crown Ridge 1 without PUC permission?
Well, just the PUC part. No, I'm not talking about the PUC permit. What I'm saying is even if they were not joint applicants, which they were here, there is nothing in the conditional use permit that would have precluded Crown Ridge from transferring the rights under the conditional use permit to Crown Ridge 1 and 2. And the comment didn't have anything to do with what's going on at the PUC level. We clearly cannot construct any part of the project that relates to Crown Ridge 1 and 2 because that PUC permit isn't obtained yet. But that's not required for Crown Ridge 1.
That isn't the way, okay.
I have a follow-up to Bob's question. So there's two towers in Crown Ridge 2, is that right?
In Grant County.
In Grant
The
County.
Crown Ridge 2 portion of the project includes only two.
Only two.
towers.
How many in the entire project?
For Crown Ridge 2,
Right.
Right now, there's 88 turbines associated with 200 megawatts.
Okay, but only two are in Grant,
for Crown Ridge 2.
for Crown Ridge 2. Okay.
Okay, I have one. Just so I'm clear, and I think Christie, or is this just for Crown or for next year? Either one. Okay. All right, Christie. There is construction on Crown Ridge 1, correct? Okay. And you guys agree with that too, or next year agrees? Okay. Is Crown Ridge the only site with growth on it?
Is it?
Is that the only site with growth on it, Crown Ridge 1?
I'm not sure. I haven't went to look at it. I've just seen the,
You say that it is. You say that Crown Ridge 2 does not have groundbreaking or no?
That's correct. There's been no activity whatsoever on any turbines that are part of Crown Ridge 2 as the projects are provided before PUC.
Okay, then with Crown Ridge 1, Christie, before the date, were all the required permits granted by the state and federal government before building be started in Crown Ridge 1 site?
I couldn't answer that because there's federal permits that are very elusive for us to find. The local building permits were not issued before they started.
We know that for a fact.
Yes, we do.
Do we?
The permits were issued.
They
The permits were issued October 28th and October 31st.
They have 3 permits.
Okay, so were they granted?
Yes.
Okay,
Not prior to construction.
not prior to the construction?
No.
Okay, so it's he said, she said.
Well, there's gotta be a
There's
date.
got to be a date someplace.